week, if you're hearing this show, next week I think is going to be the 14th, if I'm not mistaken, or 13th. I'm losing track of time. It will be also the same.
From the San Francisco.
So, I'm sorry. Assalamualaikum, Sister Kal, Namaskar to all the listeners. I think we had some glitches. This is Shahpur Ali for the Shahpur Ali Law Show, and today I have on the board with me Michael, and we are going to talk, of course, about immigration law. And if you're hearing the show another day than December 6th, if you're hearing it on December, it will be December 30th, if I'm not mistaken, and that means the recorded show. We are going to take questions live today, 510-657-1170, 510-657-1170, and anything I'm going to tell you again is my opinion. You should not act or refrain to act on the information provided. You should contact an attorney if you have any questions. So today, ladies and gentlemen, the big news, of course, there are so many things happening, but the big one is new rules that are going to come for the H-1Bs, especially the rule which basically is going to affect those who are going to be filing new H-1B under the cap of 2020. There will be some changes coming, and they're proposing it, and I'm pretty sure it will go through because it actually serves good purposes, kind of, although there are minor things that we have to wait on that can be problems. But in the meantime, we are seeing that what they're going to do, they're going to have a pre-selection for the lottery. As you know, for those people who usually what happens, people will file on April 1st, and then after that they have to wait and see if they got in the lottery, and if they didn't get in the lottery, then the next step is to wait and see. Basically, the whole 9 yards of waiting and stress, etc. But now, of course, the stress still there. There still be kind of a lottery, but there will be a pre-selection. So what they will probably do is they will have a system, a bit like they're doing for the LCA, where you basically punch in your name and your details, and they will have a pre-selection if you will be in the lottery. Once you are in the lottery, then you will be eligible to file on April 1st. And when you file on April 1st, of course, if you make it, then it will take it from there, and you will ultimately, hopefully, get an approval, and your H-1B will kick in on October 1st. We don't have exactly all the details, except we have this proposed rulemaking, which is kind of the details, but we'll have to see how the implementation will go. And they are basically saying this is going to save time, and etc. So let's hope it will be good for the people. So we don't know yet, unfortunately, if this is going to be. It is practical from my perspective. I think it's a practical thing. At least the stress is less. We will probably starting getting H-1B people contacting us. What is in, we will be doing the pre-selection, and as we open the door, we'll send the paperwork, and it will be done online. And if you qualify, we get a confirmation you are qualified. Not qualified. I mean, if you are picked in the lottery, then the next step will be you will be eligible to file it. Then you don't have to worry. Once you file it, you don't have to kind of spend money, file the case, and then the case doesn't get picked up, etc., etc. You lose the money with the lawyer and etc. So hopefully that will be good for the employer and the employee. Now, of course, there are some stuff that are going to change in the H-1B. For one, they're going to be very selective. So you not like it used to be. We were able to get people certain positions that were approvable before. Now is not even going to be in the list, and that's the part that is worrying a lot of people. Are they going to kind of use that to change the definition of a specialty occupation, which they have already been doing kind of indirectly, and that is something that is really kind of worrying a lot of people. So, Michael, I hope everybody is hearing me properly today, and this is Attorney Shahpur Ali. We're live today, which we were not live for a couple of weeks, and today is December 6, 2018, and we are almost the end of the year, and I wanted to congratulate the team. We won the top rated lawyer on AVO, and we also were among the honored professionals. So I wanted to thank the team for their good work, and hopefully we'll continue serving the community as we go. And again, the lines now are open. You can call if you have any questions on immigration, 510-657-1170, 510-657-1170. If you have any questions regarding anything on immigration, as much as I can actually kind of guide you, I'll try my best. As you know, this is usually not a consultation that we do on air. It's more like a general information, but we try our best to cover. And I know a lot of people are getting ready to go for the break on the holidays, and a lot of people are also traveling. So I'm going to talk a little bit about that, and also I'm going to talk a little bit about what's happening on the side of filing for citizenship and selective services. As you know, when you file for, let me start with the selective service. When you file for citizenship, you are, one of the questions they ask, have you registered for selective service? Selective service basically means if there's some kind of conflict or war, you should be able to, you are basically going to be kind of quote-unquote voluntary drafted. So many people have been going to, it's never been a problem in the past, but now they are kind of making this an issue. So we'll talk about that. Let me take one caller, Michael, and move forward. This is Shabra, you're live on air.
Hi, this is Avinash here. I have a question. So
yes.
I filed my H1 extension and my wife H4 extension and H4 EAD in the premium category. Mm-hmm. So my H1 extension and her H4 extension got approved, but H4 EAD status is still showing case received. It's almost like a 1 month. Do you know roughly how much time nowadays the USCIS is taking for approving H4 EAD renewal?
It depends on the case. Right now they're trying their best to delay. The reason they're delaying because they're expecting some kind of changes on the law. But most cases are taking up to 90 days to get done after the...
Even the renewal?
Yeah, everything is considered the same now. The memo of Trump says everything, even a renewal is considered as if a new application. So everything is reviewed. But that's not the reason. The reason we are thinking it's happening is because they themselves are not sure what will happen next on the H4 EAD. So, but you should get it. Give them a call. If you don't get anything within the next 2-3 weeks, give a call to the USCIS and see what's going on there. And
okay.
that's the best you can do. And then worst case scenario, you can also contact a congressman. Okay? Okay?
Okay.
Good luck to you. And yeah, this is getting really kind of nerve-wracking when it comes to, unfortunately, for people filing on the H4 EAD. For one, the H4 itself is taking forever. And now the EAD, which is supposed to come pretty much just after the H4, taking time too, and there's no real time. Some people are getting within 2 weeks, some people in 1 month. I have a few cases, I think it's been 60 days. So it is getting really kind of, there's no kind of general time now accordingly. So it's going to change. And again, your number to the studio today is 510-657-1170, and I have Michael who will be glad to take your call and pass it to us. And again, today is December 6, 2018. I know those couple of weeks people have been calling, but it was not a live show. But this week, December 6th, it is a live show. Next week it won't be live, but this week it is live. So I recommend if you want to have your questions, call this week. So please feel free to call, and if you want a private consultation, the number to our office is 510-742-5887, 510-742-5887. That's the number to our office. But the number to the studio, 510-657-1170, 510-657-1170. Let me take another caller. Chaprali, you're live on air.
Good morning. This is Guru from Sunnyvale. I have a question regarding my wife H4 and H4 EAD.
Yes.
I recently shifted my job from, let's say, Company A to Company B. They have filed my H1B. Company A provided H4 and H4 EAD to my wife. Company B is saying they don't need to file H4 and H4 EAD as my wife's H4 EAD is still valid for another 1 year. I'm little concerned about it. Can you please clarify?
Yes. Okay. they don't have to refile the EAD, but they do have to file the H4. The reason they have to file the H4, if you left company A and company A cancel your H1B after you left, that means the H4 of your wife is gone, and that means the EAD will not hold. So the part that they have to still do is what we call the H4, the H4 extension. But the EAD, she can continue using it because it's the same EAD. But they do have to do the H4 because it's a safety issue, kind of. Because if you don't do it and the company A cancels your H1B when you left, what you're going to see, that her H4 will be kind of holding on nothing.
Okay.
So it is important that they file at least the H4.
Okay, thanks for that. In this case, I reached out to them. They specifically said that no need to file both H4 and H4 EAD. Is there a way I can check the status of her and convince them, look, you guys have to file H4 as well, like USCIS?
Well, the problem is just there's nothing to convince. They are wrong, they're wrong.
Okay.
And that's a mistake that many lawyers do, and they keep arguing on that. And it's
right.
Lawyers who are not really very informed. Many of those companies now, they hire those lawyers which don't have experience and doesn't really know. I have cases firsthand where people lost pretty much their H4, they don't even know. So if they don't file it, you can go ahead and file it on your own. Just take your receipt and then file the H4 on your own just to be on the safe side. Okay? You can call me. I can do it for you too. 510-742-5887. Good luck to you. Let me take another caller. You're welcome. This is Shapurari. You're live on air. Hello.
Hi, yeah, thank you for taking my call, Shapura. It's Lalit here, and my question is I'm on green card, which is EB1 based employment. Mm-hmm. And the question is when we apply for citizenship, so is it must I should be having the job that time?
No. It doesn't work. Once you get the green card, you can get the green card. However, if when you got the green card, the next day you quit the job, they will question the job. But once you become you cannot keep a job forever. Nobody does that. But as long as your job offer at the time when it was offered and at the time you got the green card was present, you should be fine. How long you work for the company before you left?
Okay, after getting my green card, I was there for company for 2 years. And then I changed the company, and I'm still with another company for last 2 years. So it's around 4 years I'm on the job. But let's say if something goes wrong and I'm not on the job at time of applying the citizenship, is that could be an issue or something?
No, you're fine.
Okay, thank you.
Okay, good luck to you. So yeah, this is a very good question, and I get it all the time because a lot of people get worried. It's not at the time of the interview. It's at the time when you get the green card. Was it a genuine job offer? That means it was bona fide. And after that, did you work to show that genuineness? So it's not at the interview you have to have a job. But of course, you still have to show your taxes, etc., etc. That's nothing to do with that. But no, there's no problem there. Okay? Good luck to you.
Okay, thank you. Thank you.
You're welcome. Let me take another call. This is Shafrali. You're live on air.
Hi, Shah. This is Kumar.
Yes, Kumar.
Good morning.
Good morning.
Hi, Shah. Your voice is coming very low.
Oh, can you hear me now?
Yeah, it is better now. Thanks.
Okay, I'm sorry. So, go ahead.
I work for a reputed company in Bay Area, and my recent I-140 petition has been denied on a ground of education equivalency.
Mm-hmm.
I talked to my company lawyer, and the next step would be they will file an appeal, and also they will go for a new firm which suit the requirement for I-140. So I still have my H-1B valid till March 2021, and my current 797 will be expiring in September 2019. So just want to need your guidance, what could be done in that, in my case, to get the I-140 approved.
Well, first of all, the reason it was denied probably education is because they probably put you a category that doesn't qualify. They probably put you on EB2, and education.
They filed EB3 skilled worker, and I have actually a 3-year bachelor's degree from India. And in form they mention like 3-year bachelor or equivalent. But still like they denied, and that's why my company want to appeal that decision.
So it's not a mistake then there. Okay, I think they should appeal. Well, not appeal, score a motion to kind of reconsider. So let them file this, because by filing this, it will allow you to file extension on your H1B. But you're going to have a problem because down the road, because if it doesn't get approved, then you will need another one. So unfortunately, you cannot have an I-140 going on at the same time have an appeal. So it's either or. How much time you're left on your H1B right now?
So current stamping is valid till September 19th, and this I am completing my 6 years in March 2021. So around 2 years.
Okay, so you still have time. It's better than not appeal, just refile the case. Because the appeal, the problem that you have is that when not appeal or a motion to reconsider, you might end up by waiting 2 years to get an answer. So if they refile it properly, it should. Well, it's not really their fault. It's probably one of those things that are going on with USCIS. But unfortunately, I cannot tell you which is better at this point unless I look at the case. But it seems if they file under EB3, that problem of education should not have been an issue, and the refiling will go faster probably than reapplying. So I recommend that they go for maybe refiling is better, but they cannot have both.
Refiling means like a new form?
Yes,
so
start from zero.
They are thinking to go for a new form with the better language, yes. That like 3-year degree, like not 3-year equivalent kind of thing.
Exactly. Go directly and like put it on maybe EB3C, maybe.
And it's very hard like
I need to
appeal is going on. We cannot file for I-140, right?
Well, one other thing that you can do if only the I-140 is denied. Okay, only the I-140 got denied, right?
Yeah, perm is approved.
Oh, perm is approved. So they can refile the I-140. It's allowed. I repeat that. Many people don't know that. You don't have to start from scratch. You just refile the I-140 and ask them to take a copy of the labor, because there's no deadline to do that. And I've done that in a couple of cases and it gets approved. So refile it and do it properly. But if there's any mistake on the labor itself, then it'll be hard. That's why it's very hard for me to tell you unless I look at the entire case. But if it is possible to refile the I-140, go ahead and refile it, because that's the best way to do it. And most of the time, if they made a mistake, they will approve it. Okay?
And one last thing.
I have another caller waiting. Maybe give me a call at the office. We can talk 510-742-5887. Okay? Because I'm taking too long. This person is waiting. Hello? Hello? Hi? Hello?
Hi, this is Jay.
Hi, Jay. How are you?
Hi, I'm good. Thank you. I have a question related to like work from India. I'm on H1B and I have 140 approved, but due to some family reason, I want to work from India for, let's say, 5-6 years. Is it possible while on H1B?
Yeah, because once you leave, the H1B has no validity. There's no real worry about that.
But my company is okay. I can work remotely, and I want to come back again. So is it possible, like 5-6 years, they would run Indian, like US payroll, and then I can come after 6 months or so?
Yeah, they don't even have to run the payroll. It doesn't matter, because the way H1B works, it's a status thing, right? So as soon as you leave the country, you don't need to be on H1B, and you are not on H1B anymore. You become like a regular employer outside. But if they want to keep you on the payroll, it's up to them. And if they want to pay you for the salary there, it's up to them. You can always come back as long as a job is available and the I-140 is available, and the company is still willing to take you back. So
do they need to file? do they need to refile after 4 or 5 months?
Have to file anything until you're ready to come back. So
Okay.
let's say your H-1B is still good, you want to come back next year, you can come back. But if in 6 years you want to come back, then they need to revive that H-1B because it'll probably be expired by that time. But technically you don't need the H-1B while you're there. The status is what counts, and you don't need it. So you can just go like normal, and then whenever you're ready to come back, they can just revive the H-1B and bring you back.
Okay. Thank you so much.
Okay? Good luck to you. Let me take another. Shapra, you 11 a.m.
Yeah, good morning, Mr. Shah.
Good morning, sir.
I have a question in regards with filing a green card for my parents.
Mm-hmm.
So my question is that they're coming, to the States to visit me. Would it be possible to file for their green card when they are still in the country? And the second part is, I don't know, a lot of things have changed, under Trump administration. They mentioned about, doing away with these family visas and all. So has anything changed as of now? Thank you.
Okay, very two good questions. Number one, the answer is yes. When they are here, you can file it for what we call an adjustment of status. Having said that, there are issues that have been there in the past that basically the issue of the visa they come in. So for example, if you come on a visitor visa and you basically use the visitor visa to get in and file adjustment of status, if you do it within the 90 days and even after, they have a right to basically claim that you committed fraud on the visitor visa, because the intent of 214B says you cannot have an intent. So if they didn't have, the way it works, let's say they were here and then they change their mind, they say, hey, we want to stay now, you're fine. But if you already preconceive the intent, you plan everything, and then they come and they find out, then you're in trouble. The question is, what is the intent at the time of entry? So as long as your intent is fine, you can always... Hello? Yeah.
Yeah, please go ahead.
Yeah. As long as your intent when you entered was not to get a green card, you're fine. But the day you put the intent of filing and then you bring them in, then it might be a problem. Having said that, many cases the issues are the same and it can be cleared. But right now the changes that we are seeing, they're becoming more strict on that. They used not to be strict on that, so they are strict on that. They basically don't go after the green card. They go after fraud, basically, of entering on a visitor visa. As for changes for the family, it has not really changed. It just have become more strict, that's all.
Okay. So, but, the thing is that my parents are really old. And, even if I want to file for their green card, back in the home country for them, there's nobody to, do the groundwork and take them to the consulate and all those things. Mm-hmm. And so that is the problem. That is the reason I asked you.
So basically, give me a call at the office. We can discuss in more details maybe, and I'll explain to you in detail, because right now it's very hard. I've been talking about that. Actually, I put a video on this on my YouTube channel yesterday on that, talking a little bit about that. So just check it. It's youtube.com/ShapuraLaw. And by the way, please subscribe. You will get a lot of information there. But then you can also call me, and I can guide you what are the issues that can come up and whatever. And it is possible. It's just like you need to make sure that you understand the concept and the issues that the problems that are attached to it. Okay?
Okay. All right. Perfect. Thank you, Mr. Shah. Thanks a lot.
Good luck to you. Let me take another. This is Shapra. You're live on air.
Hey, Shah. Thanks for taking my call.
Yes, you're welcome. What can I do for you, sir?
See, I am in EB2 India, 2010. When this EB3 is moving very fast now, we know what is the reason for EB2 backlog now because of the porting and all this stuff from the EB1. So what is my chance if my date is current in EB3? Can I file a I-140 in EB3? It's kind of downgrading.
Okay, there are two ways. If you have not filed your I-140 yet, let's say you get your perm approved, all your intention was EB2 and your perm just got approved, you're going to file for the EB2, you can always file it on EB3 based on that EB2 perm. Okay. However, if the I-140 is already approved, then you need to get what we call an amendment of the I-140 in order to move forward to file it under EB3. So,
Sean, sorry, your line is not clear for me, so let me take the answer offline.
Okay, perfect. Okay. So, sorry for, okay, ladies and gentlemen, sometimes we have those issues. So, basically what I was talking about here is, if you already have a labor certification approved, and now you're going to file I-140, even the labor certification was prepared for an EB2, you can file it under EB3, okay? Now, if you have already an I-140 approved under EB2, moving it to EB3 requires some kind of amendment. And you will have to amend the I-140, and until it's approved, you won't be able to file it under an E3. And now the question is that since this has been done a lot for Chinese dissidents, and since India has never had this issue, we have not really done a lot in this area to know basically how they are receiving it. But it does work if you are just a labor and you're doing I-140. However, if it is already approved to change it, I have never done one, to be honest, because I never wanted to take the chance for anybody. So, but it is possible. In theory, you can amend it and get it done, and hopefully if anybody here has done that, maybe they can call and tell us a little bit about it, because I know in theory it is doable, but I have not done it. So I'm not going to lie and tell you, yes, it is going to work smoothly, okay? So that's basically my answer. So let me now talk a little bit about, Michael, I don't know how much time we're left, but I wanted to talk a little bit about what's going on in the citizenship. As you can see, laws are changing on a daily basis now. They are going to change the citizenship applications, making it harder. And one of the things that they are using very smartly now is a selective service. As you know, the selective service is basically registering yourself to be going to the army, and that has to be done if you are within the age, I think, of 23 or 27, and before 30, and by the time you get your green card. But sometimes they tell you by the time you're here, so it's becoming a problem. And many people don't even know about it. When they get their green card, they have to register. And usually you can do it online now. It used to be done at the post office. Now, the problem is what we are seeing is we are getting calls now. I have not gotten any case in fact about it, but I've gotten calls from people asking for consultation about what to do next. They're getting a hard time at the interview based on that. So unfortunately, you need to be ready for that. So one of the things, if you have not registered, is usually to put a declaration under penalty of perjury that you didn't know about it, for example. And the other thing I recommend people to do is to go ahead and do a late registration first. Even though it will be refused, at least it will show good faith. And then you put a declaration you didn't know about it. But if you knew about it and then you didn't do it, then you have a problem. But most people don't know. That's not been the issue. So for all those getting a green card now, if you're under 27, I will recommend that, not recommend, you have to go and get your name registered, a selective service. In fact, I tell everybody who just got a green card to just register. So let the selective service know that you're registered for the army, the draft, etc. And if they don't want you, that's fine, but at least you have a proof you have tried. So make sure you do that. It's very, very important. So I repeat that. Just to be on the safe side, everybody who got a green card, even as long as you're under 30, even that, even a little bit above that, I highly recommend that you register. And now, the question is that if you're not a green card holder, should you register? Well, technically no, but I had a case long time ago when I went for interview where they wanted to give a hard time to that person, say, oh, you were in the U.S., you should have registered. It was wrong, but just to be on the safe side, it's good to do it if you're legal here. Just register, and then we'll see, because ultimately if you're planning to get a green card, it will be an issue, especially at the time of the citizenship. So this is another thing that we are seeing, and we're going to see some changes on the form that they have been proposing, and I have not read really what are the details of the changes, although the notice is here on volume 83, number 225. It was published on November 21st. But let's see. Things are unfolding very, very quickly, and we are seeing a lot of people getting depressed now, unfortunately. But hey, still we are seeing approvals, and I wanted to congratulate our team for still getting a lot of approvals on EB1, especially EB2 cases, national interest waiver. So don't give up on that. Don't think, because also a lot of lawyers will look at your case on national interest waiver or EB1A, and they will tell you don't qualify. Well, the truth is that if you look at the case, most people will not qualify. However, it doesn't really work this way. So give us a call. Let us do an assessment. You've seen the kind of cases we have won, and that's one of the reasons we are getting one of the top rating on those. Please check some of our videos on youtube.com/sharp-rally-law. You will get an idea what we can do. And with me and Attorney Sharif, we have covered this topic. Sometimes it's thing that you might not think is of extraordinary ability. It is. So let us do the assessment. Of course, if you don't have anything, you don't have anything. But if you have at least something unique, you work on something unique, we want to hear from you. Give us a call, 510-742-5887. What EB1 does, it takes you out of all this headache. Number one, EB1A, for example, doesn't need an employer, so it's your own call. Number two, the dates for India is pretty high. So why would you let that go? So please don't give up on your chances. Give us a call, 510-742-5887. The website to check, attorneyonair.com, attorneyonair.com. So, ladies and gentlemen, I don't know if we have more callers, Michael. This is Shapra, you're live on air? Okay, I think we don't have any callers. So let me go over things, but we might be able to take one or two callers, 510-657-1170. Now, the next topic that I'm going to talk about, which is very, very important now, a lot of people asking the same question, is debt settlement. Right now, the economy is acting weird. It's been doing that for a while now, but more and more people are expecting some kind of crash, maybe on the house market or other things, because of first of all, a lot of people are leaving the country. We hear that already on the radio, and they're worried. They don't want to take their houses. So Bay Area, to be honest, I'll say 25 to 30% of the houses owned in the Bay Area are people on H-1B. And if they go, what happens to their houses? Well, first of all, just to let you know, the house, immigration-wise, is still yours. Doesn't matter you lose your status or not. Okay, so don't panic on that. Number two, many people prefer to basically sell the house. They don't want to take the headache, and that's going to create a lot of issues. So we can help you in settling those debts, especially if it is second mortgages or credit cards. If you're leaving, or even if you're not leaving, you're here, you have problems with debts, please give us a call, 510-742-5887. The website is yourdebtsettlementattorney.com, yourdebtsettlementattorney.com, and we'll be glad. We have done thousands of those cases in the past, but then the economy went back up under Obama, things got better, but after that now it's coming back. It's always up and down, so let's see how things unfold. So please call us, we can help you on that, yourdebtsettlementattorney.com. We can also help you with credit cards and other lawsuits. For example, someone sued you or you just call us, we will sort it out if we can help or not. If we cannot, we'll tell you. And by the way, this is not bankruptcy. I repeat that. This is not bankruptcy. This is debt settlement. It's a way basically to negotiate those debts. And it's not debt consolidation either. It's a one-time deal, get it done and move on. I know I have some callers, Michael, but just give me one more minute and then we'll take the callers. So that's one of the things too that we really want to help people with is debt settlement. And of course, immigration. Feel free to reach out to us, 510-742-5887. Let me take one caller, Michael. This is right, you're live on air. Hello?
Yeah, hey Shah. Thanks for taking my call.
You're welcome, sir. What can I do for you?
So I have a follow-up question regarding a question that earlier caller asked. I have the same situation. I changed my job, and my new company has only transferred my H-1B. Because before I changed my job, my previous company had to file my extension because my previous H-1B was expired. So once the extension was approved for next 3 years, I still stayed with that company for next 2-3 months, and then after I had a chance to work for my current company. So now they also didn't file my wife's H-4 and gave the same reason that her status is tagged with me and it's valid. So we went outside the country and came back last week, and we had a problem in immigration. So we had to convince, my lawyers had to convince them, and they actually got convinced and let us in.
No, but as soon as you leave and you back, then automatically the new H4 attaches to the new company. But if you're staying inside, they have to transfer it. That's a no-brainer. I've seen cases where many lawyers don't even know that. I used to teach a bunch of lawyers. They will always argue with me on that. So I know what I'm talking about here, because this is a mistake. And that's why you're getting this problem. Technically, what they should have done, they should have filed an I-539 for you with Company B. Because the problem now is, it used to be when you leave a company under transfer, they will not cancel your H-1B because there's no purpose for them to do that. But now what happens, the previous company, they are so scared that they will send a letter to USCIS saying you're not longer working there. And as soon as they say that, your previous H-1B gets canceled. And since the H-4 attaches to that previous H-1B, that H-4 gets canceled. If they don't cancel it, you're fine. But most of the time they will. So you have to be on the safe side. But you, by traveling outside and coming back, that H-1 that you have, you should be able to attach it. That H-4 should have been access to that new H-1 automatically because you reset it. Because H-4 doesn't have to do anything like H-1B. So that's what probably helped you. And plus, also, maybe the previous one has not canceled yet, and plus also the officer probably understood. But if the previous H-1B was canceled, right, and you didn't do that transfer to Company B, and 180 days had passed, they would not have let your wife in. Hello?
Oh, I see. Okay. So I think I'm almost. So what should I tell my lawyer now? Can they
you don't
still
have to
file
do
for?
anything now. You don't have to do anything. It's already reset at the airport. By you coming back, by you coming back, leaving and coming back is one way to do it instead of the transfer. So when you came back, you showed your H-1B, right? And the H-4 automatically, that I-94 will attach to that new H-1B that you have. So you don't have to do anything now. That's one way to reset it. You're fine. Okay?
So my wife's H-4 is fine now. It's attached to my new H-1B?
Exactly. Had you stayed, it would have been different. The fact that you travel actually helped you.
Oh, I see. Okay.
Okay? So don't stress about it. You're good now. Okay? Good luck to you, my friend. Okay?
Thank you. Thank you.
Okay, bye-bye. Let me take another call. This is Shapura. You're live on air.
Hi, sir. Good morning. Thanks for taking my call.
You're welcome, sir.
I've got a naturalization question, though.
Mm-hmm.
The INS website says if you stay out more than 6 months, you kind of lose your the credit, the stay credit that you had accumulated for naturalization. But it also says there's some exceptions. I'm wondering in what cases would you not lose your credit if you stayed out more than 6 months? I will take my answer off there.
Okay, beautiful question, actually. I won't tell you that. Yes, first of all, whenever you stay more than 6 months outside the country in one go, there are two things. Number one, it can jeopardize your green card, but you can kind of fix that part. But number two, you lose what we call the continuity of the time for the citizenship. Then what happens, when you come back, you have to complete usually 4 years and 1 day or 2 years and 1 day, depending how you're getting your citizenship done. Now, the exception that you're talking about, I've done 3 cases actually based on those exceptions, and we won. It has to be extraordinary circumstances. For example, let's say you went outside and you got sick, and it's not your fault that you didn't have a choice. You couldn't come back, okay? So you might be able, but it's again at their discretionary power. That means they need to accept what you said to them that is true, etc. Number 2, another example I got was someone who went outside in some country where they took his, you know how some countries are like, especially in those countries which has a lot of issues, they took his passport, he couldn't come back for whatever reason, and that created a problem. But he had a police report, etc., which basically we were able to prove that he had to stay. I had another case where that person's mother got sick and she died actually, and she had to stay there for the ceremony, and that worked too. So those are the exceptions they are talking about. These are really like the extreme situations. But just to let you know, these cases I've done them under Obama. So things were a lot more lenient at that time. So be careful. So even if you take a re-entry permit, the I-131, it protects the time of the green card. I repeat that, but it doesn't protect the citizenship time. So be careful. Just because you took an I-131 doesn't mean an I-131 protects your re-entry permit. All it protects is basically your what we call your time not to lose the green card, but it doesn't protect the time to citizenship. So you will have to reset it, come back here, stay 4 years and 1 day, then you can restart the case. Okay? So if you have any problem on those, you want us to kind of assess, we can do a personal consultation. Call our office 510-742-5887. So ladies and gentlemen, we are almost close to the end of the show now, so I'm going to talk a little bit recap. One of the things I was talking about before we took the callers is debt settlement, because this is becoming now again another hot topic, as we say. A lot of people are finding themselves in a lot of issues, especially those who came here and have to basically leave the country quickly, or other people who are losing their jobs for whatever reason. Right now we're hearing GM basically firing so many people. So these are hardships that we can use basically to negotiate your loans. We cannot do it for student loans, but we can do it for other kinds of bills, especially credit card, and sometimes second mortgages if your house is underwater. What it means underwater is like the value of the house is less what you owe. So we can try that. So please give us a call, 510-742-5887. And just to recap, today we were talking about the issue of H-1B, the new rules of H-1B, and that is coming up, and we're going to give more details on that. And as you know, sometimes recently I've not been writing a lot of articles because it's been hectic, but I try my best to use YouTube as a tool to put information there. But please subscribe to it, youtube.com/Shah Pirali Law. I have two YouTube channels, but the one that really works, Shah Pirali Law, SHAHPEEALLYLAW. So please check it. And our website for our office, attorneyonair.com or piralilaw.com. So today we were talking about those two issues that we are seeing. Number one, the H-1B coming up. We're going to have a pre-selection now before it goes to the lottery. And number two, we're going to also see changes when we're seeing issues with selective service. I think Michael Amit is there. Hello.
Hey, Shah, how are you?
Amit, how are you? Thank you. So I'm going to close right now. So ladies and gentlemen, I wanted to thank you. Next week, just to let you know, it will be a recorded show. So if you're hearing this show, I think it's going to be the 13th, if I'm not mistaken. That means the